I'm Jeb Butler. This is Matt Kahn. We're lawyers at the Butler Kahn law firm. Wanted to talk about a recent settlement that our firm obtained in a car wreck case, but this was not your normal car wreck case because in this case, some things that normally are easy to prove or don't have to be proven at all were big issues. The first was proving that the at-fault driver was intoxicated. We believe he clearly was, but finding admissible proof for that was tough. And then another difficult thing was showing that the at-fault driver was in the course and scope of a local store when he was involved in the crash, and that matters because in the store is liable and there's more insurance. But we had to prove that he was in the course and the scope of his employment at the time of the collision to get there. Matt, what's this case about?
Sure. So this case involved a single car collision into a tree. We represented the passenger, who basically looks over and, much to her surprise, sees her boyfriend, who is driving the car, hunched over the wheel, passed out. She screams, tries to wake him up, and he's not moving. And really, the next thing she realizes is they're going off the road and into a tree, and she blacks out. But the tree or the vehicle had collided so hard into the tree that it caught fire. After the collision, you can see a picture of the vehicle right here. The trunk of the tree is clearly, I don't know, it's clearly right in there in the passenger side where our client became stuck. And so the car catches fire. Our client struggles to get out of the car. And fortunately for her, a truck driver was passing by and saw the fire and got out and helped her. But actually, he pulled her away from the car moments before it exploded. And all of this was actually captured on the 911 call, which was very powerful. But one thing that was interesting is that the driver actually ran out of the car and left her for dead in the car, which didn't sit well with really anybody. But Jeb, why don't you tell us about the intoxication issue?
Sure. A lot of times where someone is intoxicated, that's a relatively easy thing to prove. Usually it's because a police officer showed up, noticed they were clearly drunk, and gave them a breathalyzer and an intoxilizer or whatever else. There's usually good evidence of that. Here, both parties to the collision were hurt badly enough. They were both transported to the hospital. So we didn't get that type of evidence that we normally get. But after a little squabble over it, we were able to obtain the defendant driver's medical records. And those were helpful. We'll look now at some excerpts from them. So, as this should show, the at-fault driver was talking with doctors about sort of what he was going through, and that is admissible usually as a statement made for purposes of medical diagnosis, even though it would otherwise be hearsay because someone's saying it to a doctor in order to get treatment. You can use it. And so here at the top, the at-fault driver said he was under the influence of multiple substances. The next record shows that he was intoxicated by an unknown agent, which we thought was a doctor's observation, so not hearsay, but a first-hand observation. And then if we come down a little further, there was evidence of a UDS or urine drug screen that showed positive for a bunch of different drugs. Not all of that was admissible because I believe he was given fentanyl, the at-fault driver was given fentanyl in the ambulance after the collision, so the fentanyl in the medical records wasn't admissible because maybe he wasn't on it. Maybe he wasn't in the system at the time of the collision, but lots of the other stuff was. So that is how we were able to prove intoxication. There were a lot of evidentiary fights over whether that was admissible, which were not resolved. We were close to resolving them. The judge had heard the argument but hadn't yet ruled on what was coming in, but we were confident at least some was, and we believe the defense thought we would get some evidence.
Yeah, and I'll just add to that. We've been doing this for a while. It's pretty rare that you get such a clean admission in medical records that someone's under the influence of not one but multiple substances. So we were pretty happy when we saw that.
All right, what are we talking about next? Course and scope. Are you talking about that?
Yeah. So course and scope. So generally in Georgia, the rule is that if you're going to or coming from your place of work, it's not your employer's responsibility. If you get into a wreck on the way to work or from work, they're off the hook. It's just your personal liability. But in this case, we're looking at an exception to that rule, which is where an employer, it used to be called the special mission rule. It's that we no longer call it that, but basically, if your employer directs you to do some sort of special errand that you wouldn't ordinarily be doing, but you're doing it solely for the benefit of your employer, then the employer can be responsible for your negligence on the way home. And so, at first this just seemed like a straight up car wreck case, but in interviewing,
it did not happen in normal business hours.
That's right, which I guess I should have mentioned. This actually happened around 3:30 in the morning. So our client and her boyfriend had just finished the shift and then drove several miles up the road to take the other employee home, and this happened on their way home. But basically, through interviewing witnesses, we were able to lock down that at the business, the manager, the person in charge of everybody in the store, told this person to drive another employee home. And we got the manager's testimony, and we also got the testimony of other people that had overheard the manager give that direction. And then another thing that came out through witness work was that this business had made a deal with the employee who was being driven home that they would get her to and from work, which is unusual. So we were able to argue that it was actually a condition of her employment that they got her to and from work, just like a school bus gets kids to and from work. This was their job, and so we thought that was good evidence, strong evidence of course and scope. There were several arguments that the defense had made, one of which was a compelling argument actually, but that they had gone so far out of the way that it was no longer in the course and scope. And so, those were some tough issues that we had to overcome. But ultimately, the court gave us a favorable order and said that the jury has to decide all of these things.
Yeah. The defense had tried to get the case thrown out through what's called a motion for summary judgment, but we were able to block that. The short version of that is that Matt did a great job identifying what this case was really about early on. Because if you look at it, it looks like a boyfriend or girlfriend crashed their car at 3 a.m, and you would look for the at-fault driver, i.e. the boyfriend's insurance, and most lawyers stop there. But he dug really deep and figured out this argument that they were actually in the course and scope, and then we survived with that argument. The judge said, yes, we had the right to make that a trial because there was adequate evidence, which he generated. Can't talk with enough witnesses to come up with the evidence and get it all to become matters of record. We also have to talk about damage or address damages. I'll just do this briefly. Our client was hurt pretty badly, and so we spend a good bit of time at our firm developing evidence of injury so we can present that to the jury and let them understand just what a serious case it is. And the slide behind us is something that we worked with an expert to have prepared so that we could explain that to a jury. Ultimately, this case settled, and we think that was a good result. I mean, the defense had a very good lawyer. They had good arguments for why they were not in the course of scope. We had some good arguments for why they were. Could have gone either way, but if we'd lost that issue, we essentially would have lost the entire trial. So there was a lot of risk for both sides. The case settled for an amount that our client was pleased with. So a good day for our client, a good day for the law firm, and good work by Mr. Kahn.